and it's also expensive, and therefore people should take care as to the process and the manner in which they approach these purchase.
Yeah.
We'll start by saying that land in Kenya is governed by several registrations, including the Constitution of Kenya that clearly provides for land and categorizes land into three. We have private land, public land, and community land. We also have other registrations like the Land Act of 2012. We have the Land Registration Act of 2012. We have other registrations that still pertains to land, like to say the Section of Properties Act, the Stamp Duty Act, and many others that can touch patches of land, including the Land Control Board Act. Let's start with your good question on what someone should consider when they intend to buy land. And I will subdivide that into two. What a purchaser needs to do and what a vendor or the seller needs to do. A purchaser needs to identify land, of course. You identify the land you want to purchase. You identify the price, the size, and all that. And once you are confident that you want to purchase that land, you should now approach an expert. Let's talk of an advocate. We are assuming by this time you've already identified the owner.
Yes.
And they are willing and ready to sell the land to you.
Yes.
So it's good for you to approach an expert, and for this case, a lawyer. Let's now go to the vendor or the seller. If they need to sell their land, it is also advisable that they also have their own lawyer.
Okay.
I know there are some parties that use the same advocate. It is not prohibited, but it is advisable if you are able to have your own lawyer, because there are procedures that should be done by advocates for both parties.
Okay.
Yes, let's start with the advocate for the vendor or the seller. He is the one who is supposed to prepare what we call a sale agreement. And a sale agreement is supposed to provide a number of things, provide the subject land itself, it's supposed to provide the purchase price, and other components that are required for purchase or a sale agreement for purchase of land. It is also important to note that the law provides that any agreement that pertains to sale or purchase of land should be in writing. And that is why it is very advisable for someone who is intending to sell or buy land to engage a lawyer. Because if there ever comes a dispute that needs to be taken to court, then such an agreement that should be in writing and have taken all the clauses that are required should assist you to solve such a dispute. So once this sale agreement is prepared, it should be sent to the purchaser's advocate. Let me say, by the time we come to the purchaser's advocate reviewing that sale agreement, they have done what we call due diligence. They have helped the seller in terms of conducting official searches at the land registry, in terms of doing any due diligence to know whether is this owner legit, is the title encumbered, that is to say, is there a loan on that title, is there a caution, a caveat on that title, and such kind of things. So by the time we are talking about reviewing this sale agreement, due diligence has been done. And it is so important for the purchasers to do that, because you cannot purchase a land that is encumbered. It has a loan. For example, a bank has an interest in it. For example, a caution that has been placed on the land registry. You would encounter problems when you go to register that land. So assuming the due diligence is done, then the purchaser's advocate is reviewing the sale agreement to ensure it has taken into consideration his client's needs. That is to say, the amount agreed, the purchase price agreed is well captured. There is the provision of payment of a deposit. And we have what Celestine we call the Royal Society conditions of sale that advises on how this process should be guided. For example, one of the advice is that the deposit should be 10%. 10%. So at the time of signing this sale agreement, the purchaser is advised to pay at least 10%. Of course, it is not illegal to pay whatever amount you have agreed, but that is what is advocated by the conditions of sale that have been provided by the Royal Society of Kenya. For what reason, Celestine, is that at this time of signing the sale agreement, the vendor has still not done a number of things, or has still not provided a number of documents that are essential. That is to say, the consent from the Land Control Board. The Land Control Board has not provided the land rates clearance. He has not provided the signed transfer forms. So you do not want to give too much deposit at this time of signing the sale agreement. So let's assume both advocates have agreed on the manner and the provisions of the sale agreement, and the same has been executed. Of course, it is advisable to have the two lawyers attest through their stamps for each of their clients to make that agreement more binding. The agreement again can be registered. But assuming all that process has been dealt with, the next step is for the vendor to compile what we have called completion documents. They need to apply for consent at the Land Control Board. They need to, the purchaser's advocate will draft the transfer forms. They will collect the IDs, the passport photos, the KRA PIN. They will pay the land rates. They will obtain every other completion document that is required. So assuming that has been done, and then now it is the time for handing over those documents. You only pay the balance were illicit or in exchange of all the completion documents. So at that point you are clear that there is no any encumbrance. At that point you know the consent has been issued, the land rates have been paid, they have signed for you the transfer forms. That is when we advocate that in exchange of this document you can now pay the balance.
So as we've always seen, especially when people are purchasing land, and sometimes you hear the persons, the vendors or the sellers saying that, you give, let's say, 50% of the amount and then the rest you clear. After clearing, that's when you're being given title. So we say that is illegal. That's not how it's supposed to be done.
Yes, I will not use the word illegal because there is nothing prevents both parties agreeing on the mode of payment. We have had scenarios where at the point where these two parties are going to an advocate, the vendor has obtained all the documents, the consent and all those things, and so they just want the full amount and they give all the documents. But the normal process where there is as advocated by the rules conditions of sale is that by the time you need this land, the vendor might not have all the documents. So you need to sign the sale agreement after doing your due diligence and pay a deposit. then give time to the vendor to correct all the other completion documents for you to be able to complete. And that's why the agreement sometimes gives the completion period.
Yes.
That within 90 days, we should have completed this sale. Within 90 days, you should have obtained all these completion documents.
Yes.
So let me say it is not illegal to agree on whichever mode of deposit or payment, but it is advisable that if the vendor is not giving you all the documents, don't put your too much of your money. Because let's assume that before he gives you all the document, they die. It's another whole process, and you have put all your money to them, because you now have to follow the process of the family, the administrators, filing a case and all that. Another scenario is assuming you have paid too much, but when the vendor goes to apply for a consent, the board denies him the consent for whatever reason. So you don't want to put too much of your money on something that you are not so sure will proceed. However, as I've said, there are vendors who, by the time they are engaging a purchaser, they have obtained all the documents. At that point, then it would be prudent to just finalize the sale and register the transfer.
Is there a specific timeline through which the documentation, especially now from the courts and from the lands, should take? Like now, for the case of someone who doesn't have all the documents, you've just begun the process. Is there a stipulated time that can take 6 months or whatever?
Thank you. Again, I wouldn't say that there is a law that prescribes that. Parties can agree that within 1 month, within 2 months, within 6 years, we will have completed the sale. Because there are other intricacies, like when the purchaser want to pay in installments. It can be installments of 2 years, can be installments of 3 years. So parties are allowed to agree on the timelines. However, the Law Society conditions of sale that advise on how these sales should be conducted, assuming all factors held in constant, the sale is the normal one. Is no payment in installment that are prolonged. It is advocated that the completion period is 90 days. So assuming the buyer has all the money and the vendor or the seller has all the document, or it's just a matter of applying for them, then the Law Society conditions prescribed or advises a completion period of 90 days. Yes.
Wow, thank you so much, viewer. We are going to take a short break. We shall be right back. Remember, you can reach out to us on 22914, Facebook page Mwangaza TV, and YouTube channel Mwangaza TV Kenya. Don't go away.
Unatazama Mwangaza TV, tumaini lako.
Ukitaka mali safi kuja Kemuma, CCTV utapata Kemuma, mulika mwizi, electric fence utapata Kemuma, automatic gate utapata Kemuma, fire system, alarm system, fingerprint hapa, automatic gate, mali safi, kila kitu ya security ni Kemuma. Tumetambulika Kenya nzima Kemuma. Twende nalo Kemuma, njoo na mi twende Kemuma. Vitu ni fresh, mali yote fresh, hapana deal na mtumba, kila kitu ni fresh. Ukitaka mali safi, njoo na mi twende Kemuma Engineering System. Kwa security tuko fiti, hatuna competition, wanajua tuko fiti. Suka
Kemuma Engineering Systems. We mind your security.
Disco tumecheza sana. Tumeenda sana Nyeri, Mukurweini. Pombe nimeshawahi kunywa. Hizi changamoto niliweza kuzishinda juu ya maombi.
Nini hicho ambacho ulitamani kuwa sana maishani?
Maisha yangu venye sasa tulilelewa tukiwa mayatima, nilikuwa tu nasikia tu kunyenyekea, kuenda kanisani kuomba. Mtu anakaaga ukiombea watoto wako. Nataka kushukuru Mungu kwa maana Mungu alinikujia na akanibariki. Watoto wangu wawili wameenda UK. Nataka nikutie moyo kama venye Mephibosheth alibarikiwa na akarudishiwa mashamba ya babu yake Saul na mashamba ya baba yake Jonathan. Nataka kukutia moyo mtumishi wa Mungu, usiwahi kufa moyo.
Na nami Kelvin Kariba kila siku ya Jumanne zinapotimia saa 1 na dakika 45.
In a world driven by innovation, the right skills can open doors you never imagined. At Jewel Technical College, get the skills for today's fastest growing fields. We provide hands-on training in the most in-demand technical fields. Whether your passion lies in technology, engineering, or media, we have a program designed to equip you with the practical skills employers are actively seeking. From healthcare, foreign languages, cosmetology, hospitality, to the art of a professional barista, we give you the expert training that gets you the job. You learn in a supportive and dynamic environment, guided by experienced industry professionals dedicated to your success. Jewel Technical College is your launching pad to a successful career. We offer a diverse range of certificate and diploma programs, all tailored to meet the evolving demands of today's competitive job market. We are located at Troy Sambo Roundabout, Jewel Complex, 6th floor next to TRM. Call us today on 0701 300071 or visit our website at www.jewelcollege.ac.ke for more information. Jewel Technical College, the fear of the Lord is the beginning of wisdom.
Usipitwe na vipindi uvipendavyo katika runinga ya Mwangaza. Unaweza kutufuata na kuzungumza nasi kupitia mitandao yetu ya kijamii kama vile Facebook, like and share. Ukurasa wetu wa runinga ya Mwangaza tufuate kupitia Instagram @MwangazaTV Kenya, Twitter @MwangazaTV, mtandao wa TikTok @MwangazaTV, YouTube kupitia Mwangaza TV Kenya. Mwangaza TV, tumaini lako. Unatazama Mwangaza TV, tumaini lako.
We continue with our discussion. I am with Lewis and Company advocates today, and we really want to understand the things that you should consider before getting that property, before buying that land. What are the legal channels that you need to use? And before we went for a short break, Lewis had broken down the conditions or the situations or the legalities that are involved, and he had mentioned that each partner, each member, if I should use, the vendor that is the seller and you as the buyer, each should have your legal team or your lawyer or your advocate. But then I want to ask you, Lewis, you've said that I only complete the payment when the documents have been given to me. Literally, it's not me receiving them, it is my lawyer receiving the documents. What does the lawyer do with the documents?
Thank you. It is good to state that if you are using, each party is using their own lawyer.
Yeah.
There are those responsibilities.
Yeah.
But sometimes parties can use one lawyer,
yes,
who will then do everything. Starting from the sale agreement, helping the purchaser to do due diligence, helping the vendor to apply for the consent and all
yes,
that. The challenge with that is, in case there is a dispute, then this lawyer might not be able to side with anyone because he was representing both parties.
Okay.
But then let's assume both parties had their own advocates. It is then the responsibility of the purchaser's advocate, once they receive all the completion documents, to hand over the balance and then proceed to register the RAD. And by registering the RAD, they have to do a number of things. Number one is that it is the responsibility of the purchaser to pay what we call stamp duty. So the advocate will help the purchaser in having what we call a valuation done. And as we know, currently within urban areas it is 4% of the value, and then in rural areas it's 2% of the value. So the purchaser will pay the stamp duty, and with all those documents, then they will be lodged at the land registry, and a registration is effected, and a new title reflecting the name of the purchaser is now given and handed over to the purchaser. After that is done, it is also the responsibility of the vendor's advocate to assist the vendor in paying what we call capital gains tax.
Okay.
So that is a tax on the gain that you have on the land. So in terms of the statutory fees, we can break it down to say that the capital gains tax is paid by the vendor. The stamp duty is paid by the purchaser.
Okay.
Yes.
Wow, thank you so much. Now you know, 22914 Facebook page Mwangaza TV and YouTube channel Mwangaza TV Kenya. I want us to look at the, how do we call it, the Sectional Properties Act. How then do we get to, this is a law maybe, how then do we get into the division and ownership of apartments?
Thank you. There is a law that was introduced in 2020.
Okay.
That is called the Sectional Properties Act.
Yes.
Although that was an amendment, it was there from 1978, but it was not being utilized. And an amendment was done in the year 2020 that introduced the Sectional Properties Act with its amendment. The Sectional Properties Act is a registration that helps in ownership or division of apartments, division of mansionettes, division of flats into individual properties and titles, so that people who purchase units, for example, in an apartment, or in a flat, or in a mansionette, can be able to have their own individual titles.
Okay.
Yes. So that you get, for example, in an apartment, there are several unit holders.
Yes.
There are several people who bought units, but they have their own individual sectional titles.
Okay.
Yes. The other thing I would add on that is it is a simplification of how people can purchase these units, because before these amendments, what we used to have are what we call long-term leases. So that a developer would incorporate what we call a management company that owns all the common areas. The common areas would refer to the ground, the staircases, and such kind of things. But now with these amendments, once a developer registers what we call a sectional plan, then automatically a corporation is created, and each unit holder or buyer becomes, or we call them what we call tenant in common. They become owners of that corporation in terms of the fraction of the units that they hold, but they will get their own sectional titles.
Help us understand this. If I buy this as a unit. Say we are talking of a flat with several houses, and I get a 2-bedroom apartment.
Yes.
I have my own title deed. I will be given my own title deed. Does this law or does this act also determine who either uses or owns the parking lot or the rooftop? Because there are times when you will feel like I don't know, how does that law work? Yeah.
Thank you. As I had indicated, with the introduction of the Sectional Properties Amendment of 2020, the moment a developer registers a sectional plan, automatically a corporation is created by the provisions of the law. In fact, you don't have to register it as a company through the Companies Act. Automatically, a sectional plan is registered. There is a corporation. It is that corporation then that owns the common areas, manages the common areas, or owns what, in quote, because we have moved away from that, we would call the mother title. So the unit holders, or if you own a 2-bedroom, a 3-bedroom in that flat, you have a fraction, or you are a tenant in common in that corporation, in the fraction of the unit or percentage of the unit that you hold. In simple term, though the Act does not call them that, we would say you are a shareholder in that corporation. And so, like any other company is run by the shareholders have the authority through the AGMs and all that to make rules, manage, and do all that. So you own the parking lot, to come to your question, the staircase, the roof in the fraction of the percentage you own in that unit.
Okay.
Yes.
So what are the benefits of this act to me as the unit owner?
Thank you. Number one, I would say that with the population that we have now in Kenya, this is the route that we might find ourselves in the years to come, because there might not be individual plots or properties to purchase. And through the introduction of the sectional titles, you are able to hold your own title that you can take a loan or a facility with. You are able to pass over your property to your generations, because by the fact that you have a title, a sectional title, then that is your property. It is a property that can devolve to your generations. And so number one benefit is the simplification of owning apartments. Number two benefit, I would say, is that you can take a facility, you can take a loan with your title. And number three is that your property can be passed to your generations. Yes.
Someone may have a question. Maybe I bought an apartment and I'm yet to get a title. Maybe you ask to other unit owners. Some have the title deeds while others don't have the title deed. What is the legal procedure for such a person?
With the introduction of the sectional properties, it is become easier, because the corporation is automatically created. And the moment you buy a unit, then you automatically will get your title through the corporation. However, if there are such scenarios, and especially through the former regime of before the amendments, where they used to have the management companies, some people don't get their titles, then you can be able to either sue the management company to effect and give you your title, or be able to enforce your rights through the agreement that you got. Yes.
We've had issues of disagreements arising. Maybe one tenant, allow me to call them tenant, one tenant complaining that maybe the other tenant does this. Are there rules that govern the relationship between the tenants ama the occupants of those units within a certain.
Thank you. The corporation we have talked about, and in this case, to simplify it, let's assume it's a company, because in the previous regime before the amendment, there used to be a management company. And this management company has what we would call its directors, and each unit holder is a shareholder. So it essentially, through its memorandum and articles, be able to govern how the relationships between the unit owners. It should have what we call AGMs and all that. Unit owners as shareholders can be able to pass on what they want, how they want to be governed.
Can someone own more than one unit?
Yes.
And if it's yes, does it also affect their the sharing power? Ama their ownership power now with the common facilities?
Yes, you can own several units, because once you buy a unit, you become a tenant in common.
Yes.
In the fraction of the units that you own in that. So if the constitution of the corporation then indicates that each unit holder or each title bears one vote, then it means that you will have 2 votes for your 2 titles.
Okay.
Yes.
All right. And am I able to convert my unit, my existing unit, into something else?
Yes, we have had people, I don't know the exact context of your question, but I assume that you want to ask whether you can rent it. We have had people who become owners of units, but they rent it to other people because they don't want to live there.
Yes.
So you find there are tenants within a flat that is owned. We can have so many landlords in one apartment.
Okay.
Yes.
I really wanted to I was asking this question, like if I want to convert it into something else. Initially, say it was an office, I now want to convert it into a house, or it was a house, I now want to convert it or to demarcate it into small units. Is it still acceptable?
I would say that will be governed by the constitution of the corporation.
Okay.
Did the constitution indicate that this is a dwelling place, and therefore you cannot have a commercial place or an office?
Yes.
Did the constitution indicate that you cannot subdivide a unit further? So that entirely depends on the provisions of the constitution as at the time these you were purchasing, or by any changes that can happen through an AGM. Yes.
So if the constitution states this is what it is,
Yes.
you can't change.
You can't change unless that is amended through an AGM.
Okay, fine. A nice one. 22914 Facebook page, Mwangaza TV YouTube channel, Mwangaza TV Kenya. We are here. All of us are looking about, or we've been talking about, you know, the housing in Kenya, you know, and everyone wants to get a unit, everyone wants to get a house, and more often you've been asking yourself, now if I get that house on the 3rd floor, how am I able to get my title deed? We've only been enlightened that it is very much possible that each one of you, however many you are, and depending on the size, you're able to have your own title deed, which you can use it against any other thing. Also, maybe what are your final remarks or things that we really need to know? Now we've talked of the property, now the land, something else that we really need to know before we step out, or even as we continue to initiate these processes of owning.
Thank you, Celestine. I think during my years of practice, one of the things I would always want to advise people in this area is because land is an emotive issue, and it's also expensive. Try to follow all the laid down procedures. We get some people who come to us and tell us, this is my sister, we don't need an agreement.
Yes.
But down the line there are disputes that you cannot now solve because there was no agreement. So whether you're buying land from your friend, your sister, it is always good to follow the laid down procedures that will cover you in case of any dispute. And disputes are not just created, some just happen by natural causes. Someone can die, and so many other things. So it's always good to follow the laid down procedures for you to ensure that the purchase or the sale is beyond bar.
You've mentioned that, Wakili, and then I remembered a question someone once asked me. He has bought a piece of land, but apparently the husband is late. So they had followed the due process, but I think it gets to a point where now the remaining parties have to, I don't know if it's, what happens. According to him, the remaining parties were to appear, but apparently 2 of the sons refused to appear. Can still the process go on, or every remaining member, especially the sons or the children of the late, should appear for such process to be continued, especially for those of us who are buying lands?
Let's assume you've started the process of purchase.
Yeah.
You've signed an agreement,
yes.
But before the registration is effected, the vendor dies.
Yes.
Then what happens is that you cannot now complete that transaction unless through the administrators of the estate of the deceased.
Okay.
So the beneficiaries or the people who've been left need to file for succession, as we call it, and then indicate that this property, even if owned by my dad on paper, we acknowledge he had sold it to Celestine,
yes.
and therefore you are listed as a beneficiary by the fact that you had bought.
Okay.
Let's assume they disown you, or they do not know you, or they are not starting the succession.
Yes.
The other mechanisms provided by the law, like you can cite them to be able to file that succession, and then once they file, you can be able to file your objection as to the mode of distribution, claiming what we would call a beneficial interest in the land that you are purchasing. Yes.
Wow, thank you so much for that beautiful and wonderful moment. And thank you so much, my viewer, for joining us today. Remember, this is what we do, bringing to your doorstep that which you thought you knew, yet you didn't know. Thank you so much. Once again, join us next week, same time, 7:30 p.m. for more insightful moments. I've always told you, if you've missed any of our productions, kindly visit our YouTube page, Mwangaza TV. There are more there, and maybe there's something you really want us to talk about. Kindly reach out to us, let us know, and we will surely step into it. Once again, thank you so much, Lewis and Company Advocates. May the Lord bless you and do you well. Till next time.